Which brings us to the dissent, starting with Justice Sotomayor's. Children born in the United States and subject to its laws are United States citizens. This has been the legal rule since the founding, and it was the English rule well before then. Don't you just love it when the allegedly best legal minds in the country can't even quote the Constitution accurately? As I've already shown, the 14th Amendment does not say a person subject to the laws of the United States, but to the United States itself. Not only was that not the legal rule since our founding, if it was, we wouldn't have needed the 14th Amendment. The court once attempted to repudiate it, holding in Dred Scott versus Sanford that the children of enslaved black Americans were not citizens. To remedy that grievous error, Congress passed in 1866, and the states ratified in 1868, the 14th Amendment Citizenship Clause, which enshrined birthright citizenship in the Constitution. There it has remained, accepted and respected by Congress, by the executive, and by this court until today. It must be nice to simply make up your own history to fit your needs. Yes, the Supreme Court denied citizenship, but not to children born to enslaved blacks, but to all black people. The U.S. Supreme Court decision in which the court ruled that African Americans, whether enslaved or free, were not citizens of the United States and therefore did not have the right to sue in federal court. With this type of academic malfeasance, just what can we expect from the rest of the dissent? No right is safe in the new legal regime the court creates. Today, the threat is to birthright citizenship. Tomorrow, a different administration may try to seize firearms from law-abiding citizens or prevent people from certain faiths from gathering to worship. The majority holds that, absent cumbersome class action litigation, courts cannot completely enjoin even such plainly unlawful policies unless doing so is necessary to afford the formal parties complete relief. The holding renders constitutional guarantees meaningful in name only for any individuals who are not parties to a lawsuit. Because I will not be complicit in so grave an attack on our system of law, I dissent. Apparently, Justice Sotomayor has forgotten the fact that she just gave an example that the courts are just as capable of infringing on people's rights as Congress or the President. So why should they be allowed to make nationwide policy decisions in the form of these universal injunctions, even when the fact that they do not stand up to the law? For example, Justice Sotomayor points to a previous Supreme Court opinion in support of our birthright citizenship clause, United States versus Wong Kim Ark. From there we read, a child born in the United States of parents of Chinese descent who, at the time of his birth, are subject to the Emperor of China, but have permanent domicile and residence in the United States, and they're carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, become, at the time of his birth, a citizen of the United States by virtue of the first clause of the 14th Amendment of the Constitution. Did you notice the line, are subjects to the Emperor of China? That means when the court found that Mr. Ark was a United States citizen, they completely ignored the language of the Constitution, requiring someone to be subject to the United States, not a foreign emperor. This was a direct violation of their oath of office, not to mention legally claiming a right not confirmed by the supreme law of the land. Another example of Justice Sotomayor's twisted view of history is this statement. The lawmakers who ratified the 14th Amendment understood that it would extend citizenship to all children born here, regardless of parental citizenship. As I've already pointed out, the man who proposed the amendment that added the words, and subject to the jurisdiction thereof, said on the floor of the Senate, this amendment which I have offered is simply declaratory of what I regard as the law of the land already, that every person born within the limits of the United States and subject to the jurisdiction thereof is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of person. So no, Justice Sotomayor, the lawmakers who ratified the 14th Amendment did not understand that citizenship would extend to all children born here. Now, based on these warped and twisted facts, Justice Sotomayor came to the following conclusion. The rule of law is not a given in this nation, nor any other. It is a precept of our democracy that will endure only if those brave enough in every branch fight for its survival. Today, the court abdicates its vital role in that effort. With the stroke of a pen, the President has made a solemn mockery of our Constitution. Rather than stand firm, the court gives way. Because such complicity should know no place in our system of law, I dissent. Besides the fact that a Supreme Court justice cannot tell a democracy from a republic, Does anyone else find it ironic that Justice Sotomayor is calling for the courts to fight for the rule of law while she not only ignores the law, but makes it up for herself? That is not the rule of law, and neither is it a republic. It is an oligarchy where she apparently wants to rule. Just who is making a solemn mockery of our Constitution?